Okay, all in favor?
Aye.
Okay. All right, the second thing that we have before us is the acknowledgement and resolution of an open meeting law complaint. The open meeting law complaint was filed by Ms. Sharna Favuzza on behalf of Mr. Daniel Rizzo, and I'm just going to summarize it a bit. You all were served with a copy of the complaint and the court matter, and the open meeting law complaint was at the end. The complaint alleges that the Board of Election Commissioners engaged in private deliberations as to whether the recount petitions filed on behalf of Mayor Rizzo were in apparent conformance with law. As purported evidence thereof, the complainant refers to a statement made by Election Commissioner Diane Colella during the November 23rd meeting of the board, where she stated, "We've spent many hours trying to come to a workable solution." The complaint further alleges that the Commission's November 23rd meeting, at which 3 motions were made with respect to whether to accept the petition, none of which were seconded, is evidence of such prior deliberation. The complaint alleges further that Election Commissioner Colella violated the open meeting law by privately deliberating with third parties concerning the matter of the petitions. As purported evidence thereof, the complaint indicates that she discussed the same with Captain Guido the morning of November 23rd before the meeting. So under the open meeting law, when you receive a written complaint, the board has to acknowledge its receipt at an open meeting and determine how to resolve it. The matter has to appear on a meeting notice for a properly posted meeting, and that's what you're doing this morning, and this matter was on the meeting notice for today. The board has 14 business days from the date the complaint is received by the body to respond formally in writing, and the complaint was received on December 14th, so that gives you until January 5th, 2016 to send a formal written response. Any questions so far? Okay. I'm going to just summarize the law for you briefly. The open meeting law establishes a presumption that all meetings of a quorum of members of a public body and all deliberations of that body take place at a properly posted meeting open to the public. The term deliberation is defined in the statute as an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. Provided, however, that deliberation shall not include distribution of a meeting agenda, scheduling information, or distribution of other procedural meeting documents or reports or documents that may be discussed at a meeting, provided that no opinion of a member is expressed. The open meeting law does not apply to individuals, and I can cite to a case, the Pearson v. Board of Selectmen of Long Meadow case, which says, in part, the plain language of the open meeting law reinforces the conclusion that a meeting of a, quote, subcommittee, as defined in the law, does not include a subcommittee of one, and that the definition of a term quorum and its use in the definitions of meeting and of deliberation indicate that the term is meant to signify group action. Okay, so that's the way the law is written and is interpreted. So here, I suggest to you that the allegations at issue are simply untrue. The reference made by Commissioner Colella at the meeting concerning the time spent to identify a workable solution with regard to the recount petitions was not a reference to discussion between a quorum of members, but instead referring to her many discussions with counsel concerning the topic. Moreover, there were no emails to the commissioners regarding Commissioner Colella's feelings, ideas, or belief about the subject matter of whether the petitions complied with the law. Commissioner Colella did not notify members by email, did notify members by email of the scheduling of the meeting, which type of email is expressly excluded from the definition of deliberation. Although I cannot be certain, I would gather that the failure of the motion to receive a second was not evidence of any violation, and this is the part I am not certain of, that it appeared to be as a result of the lack of direct case law on the issues after I described the law both supporting the acceptance and the rejection of the petitions. And as Commissioner Colella stated at the meeting, that the commission itself was in an uncomfortable position. Additionally, legal counsel made clear, I made clear that if the board did not vote, such action was equivalent of a rejection or a passive defense, and the parties in interest would have to make their arguments to a judge who would then decide whether the recount should move forward. And in fact, that's exactly what happened. Finally, any member of the board could have spoken with any other person, meaning not a board member, concerning the matter of whether to accept petitions without violating the open meeting law. As indicated, case law stands for the proposition that the open meeting law applies only to governmental bodies and not to individuals. Thus, although my understanding of Commissioner Collella's conversation with Captain Guido was only with respect to the time of the meeting, even if she had spoken with him about the substance of the board's action later in the day, such conduct would not violate the open meeting law, just like it wouldn't have violated the open meeting law for any other member of the board to talk to any person not on the board about that subject. Is there anything further in terms of relevant facts or information that any of you would like to bring up at this point? Does it seem accurate of your understanding? Okay. So I have prepared a draft manner to resolve the complaint, and you do have it in front of you, but I'm going to read it out loud as well. To resolve this matter, the board may wish to take a vote similar to the following. The board received on December 14th, 2015, an open meeting law complaint filed by Sharna Favuzza, Esquire, alleging a violation of the open meeting law as a result of improper email correspondence or other deliberation by the Board of Election Commissioners prior to its November 23rd, 2015 meeting. And as a result of Election Commissioner Colella purportedly discussing the matter with persons other than the board votes to resolve this matter as follows. The board asserts that the actions complained of do not violate the open meeting law. Election Commissioner Colella's statement at the November 23rd, 2015 meeting was apparently taken out of context, as a quorum of the board did not deliberate outside an open meeting concerning the matter of whether to accept the petitions or of the legal implications thereof. However, Election Commissioner Colella did discuss the matter at length with legal counsel. Election Commissioner Colella was aware of the application of the open meeting law, and so she did not email about the substantive issues at all, or otherwise discuss the same with a quorum of the board prior to November 23rd, 2015 at the meeting. The first discussion between a quorum occurred at that meeting. Election Commissioner Colella sent a scheduling email to the members, which did not violate the open meeting law. The open meeting law does not apply to a single individual unless the individual speaks to a quorum of members of her board, and therefore Election Commissioner Colella's brief discussion with the police captain about the time of the November 23rd, 2015 meeting of the Board of Election Commissioners does not violate or otherwise implicate the open meeting law. And further, the board authorizes and requests that Attorney Goldberg prepare a response to the complaint to be forwarded to the complainant and the Attorney General's Division of Open Government consistent with this vote. Does anybody have any questions about that proposed resolution?
No, not at this time.
No. Okay. So if someone wanted to say so moved, they could. Okay. Is there a second? Madam Chairwoman, can I respond to that, please? Under the open meeting law, there is no right to speak at a meeting of the Board of Election Commissioners. The open meeting law does not guarantee any person the right to speak except for the chairman. The commissioner can if she chooses, but she's not required to.
Madam Chairman, again, I'd like under Massachusetts general law the right to speak, with your permission. Excuse me?
Madam Commissioner, you don't have to allow that. You may if you want to. I'm not certain that there's anything to be gained from having outside input on what the commission did or did not do. You know, to the extent that the commission has any questions or wishes to discuss the matter further, that's absolutely fine. However, from my experience with Commissioner Colella, I can tell you this is my understanding of the situation that led up to the statement made at the meeting, and that is the sum total of the intent of that statement. And whether you want to hear from any parties outside of the commission is a policy matter. Okay. All right, so that leaves us with a motion on the table. Is there any further discussion that the commission wishes to have about this? No. Okay, Madam Chairwoman, you can call for the vote. All those in favor?
All those in favor? Aye. Aye.
Okay, so it's a 4-0 unanimous vote. Is there any other business before the commission during this meeting time?
No.
Is So therefore, the other meeting was posted separately, correct, Commissioner Colella? Yes, so you can vote to dissolve the meeting. Okay. All right, thank you very much.